Welcome to the Constitutional Amendments Review session. Just a warning to my students that this will not be a comprehensive review of the Constitution or the content of the Constitution test. You also need to be familiar with the 7 articles of the Constitution as well as its historical background and the philosophical points of view that we've discussed in class. As well as the 6 court cases I brought up and are on your study guide. For our purposes here, we'll go through the amendments one by one, hopefully explaining them in more detail than we were able to get just in class. The first 10 amendments to the Constitution are known collectively as the Bill of Rights. There originally were 12 amendments included in the Bill of Rights, 2 of which were not originally ratified. One was actually taken up again and ratified in 1992, crazily enough, as the 27th Amendment, and one of them failed to ever be ratified. So of the original 12, there are 10 that were ratified. These were all discussed, written, and ratified during and slightly after the ratification of the Constitution, and are generally considered to be really a combined document with the Constitution itself. Those who were afraid that having a strong federal government created by the Constitution would militate against individual liberties and rights were concerned that the Bill of Rights be passed. And the fact that it was included, or at least guaranteed and then mostly included, helped many skeptics of the Constitution to eventually sign on. The First Amendment, generally thought of as the most important of our amendments, since it is the means through which we guarantee our other freedoms, was the one that most of the framers of the Constitution were primarily concerned to include. This includes freedom of religion, freedom of speech and the press, freedom of assembly, and the right to petition the government for redress of grievances. This 4th provision is really not referenced in case law in recent times, but was at the time very important to colonists and framers of the Constitution who had lived under British rule and not necessarily enjoyed this right. A few important things on the freedom of religion. 2 major clauses that we look at there are free exercise and the Establishment Clause. So really what the Constitution is, or the First Amendment rather, is saying is that the government is not to unreasonably limit the free exercise of an individual's religion. In the context of the First Amendment's history, framers may have had in mind primarily a Christian audience. They probably weren't thinking of the pluralism which we have now of many religions coexisting. But this principle does apply, of course, now to those of different religions rather than just to simply those of different denominations. The Establishment Clause was included so that there would not be an American church to which everyone had to belong and were forced to pay tithes, such as existed in England with the Anglican Church, as well as in a number of other European countries. It's debated now to what extent this Establishment Clause should limit or modify government and religious interaction, as we'll see in this next slide. The limitations which the court currently interprets as to be inherent in this freedom of religion are summarized in what's called the Lemon Test, which is a 3-part criterion that the majority opinion in the Lemon versus Kurtzman case agreed upon. First, any government action must have a secular purpose if it's involved with a religious organization. For example, government funding that would go to a private school for any purpose must be specifically geared towards the secular end of that institution. For example, teaching algebra or feeding students breakfast who are not wealthy or something like that, which the government would hope to do for any citizen, not just those of a particular religion. Of course, this particular part of the Lemon test is much debated, and there's lots of current case law about whether any funding at all that goes to a private school with a religious affiliation is in fact supporting that religion, is in fact breaching that establishment clause. Thomas Jefferson, although this language is not found in the Constitution or any of the amendments, spoke of a wall of separation between religion and the state. And this is basically the approach that the Supreme Court has subsequently written into our constitutional heritage. First part of Lemon test, government action must have a secular purpose. Second part, the government action must not advance or inhibit religion. Third, it must not excessively entangle the government and religion. For example, getting government folks onto like the boards of denominations, or the other way around, having some sort of religion czar for the entire country who would attempt to deliberate on doctrinal matters as a state official. These things would not fly under the Lemon test. Of course, any criterion that the court sets up, it can eventually overturn, as has happened several times in the court's history, and several times very, very well, or for good purpose, such as in the overturning the Dred Scott case. Another important First Amendment right, is our freedom of speech. But this does have limitations, as I think we'll see as we look at all of the amendments. None of them have been construed by the court to be absolute rights. You don't, for example, have the right to practice religion in a way that is directly harmful to others around you. Although people of different religions might say that of each other's, that just, for example, being a Christian might make you a jerk. It doesn't necessarily represent a breach of the freedom of religion principles, but of course there's shades of gray all throughout different people's interpretation. But so far what we'll be looking at here are really the court's workings out of these freedoms in balance with the freedoms, so to speak, of the community. These individual versus communal issues will come up. One way that does is with obscenity, which includes things like child pornography, gives the government some control over the media, particularly in what goes over public airwaves, which can be accessed by anyone at any time.